Hello. What's up, everyone? Welcome into another episode of DoJLife RP. We're getting in here as Miss Bliss. We are finally getting State v. Banks over with. Shout out to Crazy Blake, CC Hillbilly 0335, and Shoddy Tiger 3603 for the follows. Welcome to the Terror Squad. Happy for you to join us. All right. We are getting this road on the show. Okay, hello.
Oh, hello.
All right, couple of housekeeping things real quick. With this
What you got?
case. Make sure I'm whispering. So he has not received a fine or jail time. If he is found guilty of any of his charges, he will be fined and detained for those tonight.
Gotcha. Okay.
So this is one of those. This is the case where the ankle monitors were put on before the program went live.
Gotcha.
So he doesn't have any fines or charges on his person, or any fines or jail time on his person. So if we find guilt in any of his charges, then we'll also be determining his fine amount and jail time amount. So if that happens, the bailiffs will take him into custody, take him down to cells, and then SAST will take custody, transport, and book him.
All right. Understood.
Cool. That's all I had for you, Coleman.
All right. I'll pass it along to the other two that's out there.
Thank you very much.
Good to see all three of you.
Yep, glad we can all be here. All right, for you, sir.
Thank you.
There we go. I knew everyone was gonna need food. I went and gave Pizza This a lot of money.
I appreciate that.
I walked in. I said, "You're about to be paid today. I need 20 of slices of pepperoni and 20 teas." And there were 2 of them. And the guy that was there goes, "I'll go start making the drinks."
Very good.
But they gave me a discount because I'm bulk ordered, so that's the bright side. I get 20% off. I'm gonna drink this invisible tea real fast. Okay.
So what's the game plan gonna be?
So it'll be okay. Blah, 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 blah. Okay. You got normal court proceedings. They'll have their opening arguments. We'll start with state, then I'll go to defense, and then I'll allow state to call forth their first witness if they have any. If not, then we'll allow defense call forth a witness if they have any. And then we'll go from there.
Okay. As far as objections, who's gonna be the ruling? Who you want to be the ruling judge? I assume you'll probably. I was just gonna leave it to you.
Yeah, that would be me since I'm the head of this case.
Okay. Did they ever submit?
Witness list?
Yeah,
Yes, they did.
that's probably pretty far back.
Yes, it is.
I found it here. At least I see the. Okay, there they are, both of them.
Yeah, they're both there. I forget.
Do we know if they've already got inside or waiting for us, or?
I saw prosecutor out there. I haven't seen defense yet. Catch you up. What I was talking to Coleman about, Brown, was
Yes.
he was one of the subjects that got an ankle monitor placed on him before that program went live. So he only has charges. He hasn't been fined or jailed. So if we find him guilty on any of the charges, then it'll also be up to us to determine the fine and jail time, and then bailiffs will take him into custody, take him down to cells where SAST will take him for processing.
So I actually get to sentence somebody,
Yep.
possibly.
And we'll actually possibly get to sentence somebody tonight.
It's for Tim Banks, right?
Yep, State versus Banks.
Yep. Okay. Just wanted to make sure I got it pulled.
You got the incident for that? Let's see here. Incident
What is this?
number. Oh, here it is. 947 is the arrest report. All right, yep. I wanted to at least get that pulled up on the MDT here. He's facing.
Did you get it pulled up on the bench as far as the?
I have not set up the thing on the bench yet.
Do you want me to, or do you want?
If you want to go ahead, since you're right there next to the desk, if you want to go ahead and put that case together.
Okay.
I will say be careful when you're adding people. Don't hit enter, hit OK on the button. Because if you hit enter, you'll find yourself on the invisible menu.
You said it was 9. What was the incident again?
947 is
947.
the incident/arrest report.
Gotcha.
And let me see.
Well, I'm ready to get cracking.
I'm trying to find the witness list real fast so I can refresh my memory on who is being called.
I'll repost them here.
All right, I got State's gonna has Matt Winters, Jason Love, and Tommy Banks. Did it? Was there anyone for defense? Nope, you found it.
Defense looks like
No witness.
no. Okay, well.
All right, that makes it easy. Put my phone on airplane mode so I won't be disturbed during this case. All right, we just need to make sure that all parties are present and accounted for. And then we can get going. I see counselors out there. I don't see all parties.
Yeah.
Well, this might be a quicker case than I thought it was going to be.
Is the defendant gonna be Daniel Sanders, right? Or is it different?
No what?
Defendant is gonna be Daniel Sanders.
Yes, he's the holder of the SAST bank account.
Just wanted to make sure.
Yep.
I didn't put the wrong person.
Yeah, so that's something that I haven't had a chance. I was going to go over with you on that case that I was overseeing you on,
Right.
with how we handle the money. We're, as the judge, we're able to touch the pockets and the bank accounts of people.
Right.
Okay.
Right.
And then thanks, got that, and then
Yeah, so when you're setting up the docket, the person that you put on the docket for the fine processing for SAST is Daniel Sanders, who is the head of SAST, and he holds the access to their bank account.
okay. So adding jury is completely out of the question. Add Brown and myself to the case thing, but we posted the case publicly. I mean, we could post. Is it? Are we closing the doors to
No.
the public?
No, it's an open door case.
Okay. We can publish to. Apparently, we can publish to Discordia.
Oh, interesting.
I'm gonna start the court proceedings, but I'm also gonna publish it to Discordia. See if it works.
Okay.
Oh, what's the charge fee? How much is the amount?
That hasn't been determined yet because we.
I can't.
Okay.
You have not set up this case right. Please check the configuration. So, I gotta update the jury. God. I can't even move on the jury people. What would be the potential charges? I guess, and as far as fines and everything.
I'm working on that.
Okay. Yeah. Should work after you do the actual fee itself, then it should be good.
Put 39,000. Well, we'll put the max fine amount because prosecution did ask for us to consider max fines and jail time. So we'll just put the max for right now, and then if he's found guilty on anything, we can discuss from there.
Okay, I can't put the current fee. Won't let me at all.
Put what?
Oh, this is gonna be a while. I have to do it by a mouse and keyboard. I gotta I gotta manually hold my finger down.
Ew. Like to set the fine amount? That's disgusting. Why is it doing that?
Yep. In order to set the fine amount, I gotta do that. That's fucking disgusting. Yep, I'm at 1,000, so just give me a moment. Damn, doesn't even want. That's crazy. Doesn't even change it.
Hmm. Are you trying to put a comment in it, or?
I'm sorry?
I said, were you trying to put a comment in it or something?
Nope, I just did 39000 and hit the OK button. Do you want to try and see if you can add people to the jury? I think that's what we gotta do. Oh, shit. There we go. Yep. Shit. I can't even. Okay, so I added 2 people to the jury list. 39's there. Beautiful. There we go. You can only start the court proceedings if you're the assigned judge.
I got it. Alright, it started. Are all parties present yet?
I cannot see none.
Hello? Do we have all parties present yet?
The counsels are here. The defense is not here. The
Defendant?
defendant, yeah.
Client's not here.
Alright, we're starting. I'm getting answers. Defense, where is your client at?
Your Honor, I've been in contact with him up until this morning. I haven't heard anything from him since. I did let him know to come to court today. I'm not sure when he's going to be here.
Well, I might be putting out a warrant. Okay. All right, defense. D-
Off to a swell start.
Who? Okay, whose phone is ringing? All right, defense. Can you please try to get in touch with your client? They have until 25 to get in touch. If not, we're going to proceed forward with this case. It's been on the docket for way too long.
Yes, I understand, Your Honor. I'll get in touch with.
All right, thank you. Until then, this court will be in recess. All right. If he does not show up, then he's going to get fined for failure to appear, and
a warrant.
he's getting a bench warrant for obstruction because he was notified when this court case was going to be. He's had ample opportunity to say it wouldn't work for him. He even reacted to the time that I put out that it was scheduled for. So I know he's aware of it. So
Interesting.
but either way, this case is going to move forward tonight. Because we have all judges present, we have both counselors present, and defense only wanted. You good?
Yes.
Okay. The defense counsel's main thing that they wanted was all three judges to be present for this case. So all three judges are present now. So we've met the stipulation that defense wanted for this case, so we can move forward with or without the defendant present. If he doesn't show up one way or another, if he doesn't show up, he'll just get a warrant.
As far as the charges for this case, though, we'll just continue as is.
As is, yep. We'll let the court case proceed, and we'll go with whatever the outcome is after this trial is completed.
Okay.
But they got until 2025 to show up. If they don't show up, then I'll put it on the docket that they're found to be in contempt of court for failing to appear, and that the court will proceed with the trial as scheduled and planned, and a warrant for his failure to appear will be issued.
Copy that.
Any objections to that, Brown?
Nope.
All right. So now we wait. He's got 5 minutes to respond to his attorney.
Mm-hmm. At least we've been getting pretty good weather. That's good.
Yeah, that is good. Oh. All right, so now we are just waiting to see.
Hello, this is Judge Aries. So I wanted to know, as far as
So we're waiting to give defense counsel a chance to get in touch with their client. He knew that today was his court date. He even reacted to the message that we put in the docket about the time his court was taking place. If he doesn't show up, then he's just gonna get a warrant for his arrest for obstruction. And we will proceed forth with his trial. This case has been going on for like a month, I believe. So it is past time for this case to be handled. Let's see, when was this opened? looking back at the docket right now. I guess I could do this. I have the incident right here. So this incident occurred on 4/26, so over a month ago. This case has been going on for over a month. It is time to get this road on the show and get this case over with. Okay.
When I got the time, might as well call EMS, see if they got the report for your mother yet.
Press X it out.
I'm sorry?
I said press X to out.
Yeah, right? Oh, they're still, quote unquote, working on it. It's, oh.
They've had how long to work on it now?
About a month and a half, actually. Minus, well, we did the HIPAA last month. We did the quarter the month before. So,
Now it sounds like
Mr.
it's
Brown,
failure.
You should be able to see this case.
Now it sounds like
your thoughts?
it's failure to comply with the court order.
Which case is it?
That will be CC0055. Since we're waiting, what do you think?
CC0055?
Any question?
Correct.
Am I looking at the right one? I've seen nothing about medical reports in here.
It was more that I think she told you the wrong one. Uh, 5-3.
5-3. Well,
It's 5-3, not 5-5.
He's not shown. No show.
Okay, so he will be getting a warrant for his arrest.
They're also defense is requesting, to the state if they're okay to proceed as is without him. They want to see if the courts will allow it as well. I said, okay. I didn't respond to it. I'll let you.
Yep, I'll allow it. This has been on the docket for over a month. It was open on like 4/26.
yeah, it's got to go.
So he'll just get the fine for failure to appear, and he'll also be a warrant for his arrest will be issued for contempt of court.
Okay. Yeah, Mr. Brown, when you have a moment and when you get a chance to look at that, let me know what you think of that case, and you can email me if you'd like.
Okay. In the meantime, let's go knock this out.
All right, let's do this. CR 1076 State v. Banks is now in session. Defense, I've heard that you have been unable to contact your client.
Yes, unfortunately, Your Honor, I don't believe he'll be present here tonight.
Okay. Defense and state, any objections for us proceeding forward since this case has been on the docket for over a month?
No objections for the defense, Your Honor.
No objections for the state.
All right. This case will move forward without the presence of the defendant. I will make it noted for this docket that the defendant did acknowledge his court date being today. and failed to appear, and thus I will be issuing a fine for failure to appear as well as a bench warrant for his arrest for obstruction of justice for failing to appear before this court when he was ordered to do so. With that stated, we will move into opening arguments for this case. This case is CR 1076 State v. Banks. The charges on the docket are as follows. 1 times 408 obstruction of a government employee, and 1 times 602 possession of controlled substance, large amount / personal use or stockpiling. At this time, State has the floor for opening statements.
Charge of obstruction of a government employee. Is the mic on, by the way?
Yes.
Okay. The charge of obstruction of a government employee is supported under subsection 8 based on the subject's repeated interference with law enforcement ability to safely conduct their official duties under subsection A. A person commits obstruction when they willfully prevent or attempt to prevent a government employee from conducting their duties. Here, officers were actively attempting to secure and investigate the scene when the subject initially left the area and then deliberately reinserted himself into the ongoing incident while armed with a knife. His return to the scene while visibly holding a knife immediately disrupted law enforcement operations and created a serious officer safety concern. Additionally, under subsection B, obstruction occurs when a person fails to comply with a lawful order after the repeated attempts. Upon returning armed with a knife, the suspect was given no fewer than 4 separate lawful commands to drop the knife. The subject failed to comply with orders up until the 4th command. Those commands were lawful, directly related to officer safety, and necessary to allow officers to gain control of the situation. The refusal to obey repeated commands forced officers to divert their attention from their original duties to addressing an escalating armed threat. By returning to the scene armed and refusing 4 direct commands to disarm, the subject both attempted to prevent officers from carrying out their duties and failed to comply with repeated lawful orders, thereby satisfying the elements of obstruction under 408A and 408B. The charge of possession of a controlled substance is supported under subsection 602. Officers reportedly located 13 prescription of oxy containing oxycodone on the person, with the identifying prescription labels ripped off and removed under subsection 602. Possession of more than 10 units but fewer than 15 units of a controlled substance constitutes possession of a controlled substance indicating personal use or stockpiling. Oxycodone is a controlled substance, and the recovery of 13 units strongly supports the quantity element required under the statute. Furthermore, the removal of the prescription oxy prevented officers from verifying lawful possession, ownership, prescription information, and dosage authorization at the scene. The unlabeled oxy reasonably indicated concealment and unlawful possession rather than ordinary prescription use, considering the quantity of oxy, the multiple oxy involved, and the deliberate removal of identifying labels or markers. Officers had probable cause to believe the subject was unlawfully possessing a controlled substance.
Void headaches, nausea, hell hydrate.
Eric coming in with the hell hydrate. Thank you. Defense, your opening arguments, please.
Yes, thank you, Your Honors. And ladies and gentlemen of this honorable court, today we hear the state's case against my client, Tim Banks. This is a case based on opinions, subjective interpretations, and assumptions. Now, much like the law enforcement officers that Tim encountered that day, Tim is a dedicated, hardworking guy. He is a proud resident of the city of Los Santos, He's currently
trying to
working
do
on getting a
character
trucker's
build.
license so he can make an honest living. Your Honors, I'd like you to imagine the day that you got your first job. I'm sure each of you had to go through many, many hoops to get to the dream job you all have today. Tim is one of those people, and on the particular day in question, he found himself looking for a job. Now, what began as a simple job search turned into an unfortunate and perplexing confrontation with off-duty cops who exercised unofficial police authority, arrested my client's family member in front of him, and then arrested him when he didn't immediately follow their orders without question. Ladies and gentlemen, this case concerns whether or not Tim intentionally obstructed law enforcement officers from performing their duties and arresting another individual, his brother, Tommy Banks. Now, the state has promised to explain the actions of the officers who, in witnessing a simple battery by a third party, later reported that my client made them fear for their lives and who threatened to shoot my client even while he was unarmed. The evidence will also show that multiple conflicting commands were given to my client and that he complied with several of them without delay, all while witnessing his brother being arrested. The state will attempt to justify these actions by saying that the evidence speaks for itself. But as officers of the court, we know evidence is a matter of context and requires explanation. In fact, only witnesses can testify as to the facts of what happened. When we leave aside all assumptions, speculation, and excuses, only the facts remain. And the evidence will show the fact that my client never participated in a crime, the fact that he was threatened with deadly force, and the fact that he reacted to escalating chaos in a reasonable manner, which ultimately resulted in his arrest. After you have a chance to consider
going
all of the
good.
evidence
How are you,
before
Eric?
the defense will ask the court to find that the state failed to prove beyond a reasonable doubt that my client intentionally and actually obstructed the actions of law enforcement, and that the state failed to prove
Hanging
beyond a
out
reasonable
with
doubt
you over Alex?
that my client
Good.
unlawfully possessed
Oh, you're being
an
abused in
amount of
Alex's
controlled
channel.
substances to
Very
meet
good.
the requisite elements of Title VI, Section 2. Thank you.
My cam, it's right here. I just have it turned off for this. It throws people off when I use my feminine voice. State, you can call your first witness.
It appears that none of my witnesses are available to attend today.
Oh my god. A defense, do you have any witnesses to call?
Not at this time, Your Honor.
Alex is another judge seated on this. We have a 3-judge case going. All right. Is there any arguments that either parties wish to make about the current evidence that has been discovered on this case? Outside of what has already been argued.
Your Honor, I would just mention that none of the evidence that's in discovery has been formally admitted into court, and therefore it would be improper to consider it in the finding of guilt or not guilt. I advise us to consider that although this is a bench trial, it is to be treated synonymously with a jury trial, and that the evidence presented before the court in this trial is the only thing that is at issue. I'm sure the state would agree based on the fact of law.
I guess you would be correct in that.
I'm gonna kill everyone. State, do you have any evidence that you'd wish to officially submit onto the docket in the courtroom?
1 minute, Your Honor.
I'm going to fucking kill these defense attorneys, bro. Yep, they're just sitting here being pretty until we go back for deliberations. Because technically everything that was discovered on the docket in pretrial is evidence in this in this court because the docket is also treated as the courtroom. Are they? I'm not surprised.
Could we recess to chambers possibly?
Yep. While the state takes care of their thing, we're going to recess for a couple of minutes.
Okay. Food for thought here. While the defendant should have been here, this was scheduled at least 72 hours in advance.
Yeah.
And he did and should rightfully receive a warrant for not doing such. It's not like he's incarcerated and he has to be transported here. The guy's out on his own free will.
Mm-hmm.
However, the state, he should have admitted this stuff well before
Well in
today.
advance.
So now he's also providing an undue burden. Even though currently the defendant is in the wrong for not being here, the defendant still presumed innocent.
Yeah, right.
And so he is still having the burden of this.
I will make a statement on the defense's claim about items needing to be officially entered in the docket. Technically, since this is a bench trial, once it's submitted onto the docket, that docket is considered the courtroom docket. So all that evidence has officially been submitted into this case. And it is on record as being evidence for the case.
As far as the recent part of evidence that he just submitted, that
What did he just submit?
He just submitted an evidence case 1067. He submitted a whole good God. Yeah.
Oh no, that he that document's been on the record. He condensed everything that's been submitted into one form, and so he could quick access it.
Okay, gotcha.
Yeah, all that had already been discovered during the 10-day discovery window. I think he was just trying to track down all the evidence. The docket he made that combined all the evidence before we set the trial date for easy access, and then he just reposted it because I do remember looking over this document. It's already been submitted. It's just for him to get quick access to it.
So I see the evidence witness list and everything, and there's
Right, but we still have to formally enter it as evidence. They can provide it as a matter of record, but we still have to approve it, whether it's a bench trial or a jury trial. We've not done either. As
Okay.
Far as
Yep. I see what's being said now. All right.
Yeah. Which is a valid argument as far as I see.
It's been so long since we've had an in-person trial. I'm most of my cases keep going to plea deals. So I'm like, how do you trial again?
If he's not prepared for this case has been going on too long on both parts. Granted, if this does not get sorted on either one of their parts, I say we declare a mistrial. The warrant stays active because he failed to appear.
Yep.
But I say we declare a mistrial. I don't think we've had one of those in a while, and this would be very fitting for one.
Yep. All right.
Nobody's ready for this, and it's wasting the court's time.
Yep.
Yeah, especially the fact they brought no witnesses. They're open arguments.
We'll let state formally submit their evidence, and if it goes nowhere, then we'll move for mistrial.
Sounds good to me.
All right, let's get this finished. Okay. State, are you ready?
Yes, Your Honor.
All right, defense, are you ready?
Defense stands ready.
All right, State, do you have any evidence that you wish to submit to this court on the for the official docket?
I submitted in the docket for you, Your Honor.
What are you presenting? What evidence that you've discovered are you presenting to this court?
It is going to be the oxy that was recovered, body-worn camera footage, and then the arrest report itself.
Objection, Your Honor. For Rule 103 of the Rules of Evidence, all evidence must be authenticated by a witness or a certified chain of custody. You're going to need someone to speak on what this is and where it was coming from, rather than, just putting it here and asking us to believe what you say about it. That's what witnesses are for, after all.
Valid.
State, any counter from you?
No, Your Honor.
Oh, dear Lord. All right.
I'm with him on that one.
All right. Objection sustained. Defense, do you have anything that you would like to submit into evidence?
No, nothing to submit, Your Honor.
Go back to recess.
All right. This court's in recess.
God almighty.
Oh, Lord. I need to turn the mic off. There we go. Sorry, my mic didn't want to turn off.
He just killed his case. He just cut it right at the throat.
Yep.
How do you?
It's
I mean, kudos to the defense. I was wondering if somebody was gonna catch it. Holy hell!
although Mr. Brown, the fact that you made that comment and the mic was on and everything, that's not something you want to be doing as a judge.
Oh, my
You're gonna
mic
be
was
there?
off.
Okay, I was able to hear it as far as your.
Well, it's because we're in close proximity to each other.
All
Next
right.
time, just keep your comments inner, because if they catch wind of it or whatnot, they can.
I want another case that actually
turn
worth the
very
shit.
bad. Okay, they might file a formal complaint if they so choose. Just for next time, okay?
All right. So at this point, what are we thinking?
I think
Well, this is no longer a mistrial.
or not mistrial, but set the warrant out, and then let the.
I mean, this. As far as I see it, the state just slaughtered their own case. They apparently can't follow the rules of the court as far as the handling of evidence goes or how to present it. That's not a defense problem. That's a state problem. They just either wasn't aware of it or they're not.
No, they're fully aware. I think they didn't. I think they fully had intended in awareness of it. They just chose
didn't.
not to follow that guideline.
Yeah. I mean, at this point, I don't think it's a mistrial. He killed his case. He does not have one currently.
Do we take closing arguments?
We can, just for a matter of procedure.
All right, and then dismiss with or without prejudice.
Here's the thing: is he technically has evidence to prove at least one charge.
Mm-hmm.
However, procedurally, he killed his case. So it's one of those. Could they bring it back and a more experienced attorney know what he's doing? Could probably prosecute it, sure, but that's the thing that we've got to determine.
Yeah, from everything I've seen with this case, I've dealt with this case. There is wrongdoing on Tim Banks. It's just the way that this was filed, like
Worded.
the way that this occurred in the trial is a goddamn mess. This whole case is a goddamn mess. So,
but then again,
I know.
Are we going to dismiss it, or are we going to acquit the guy? Because if we acquit him, they can't bring it back again. In which, as far as I see it, again in my jurisprudence, is that he's still innocent. I understand he's going through a criminal trial, but he is innocent. Yeah. The burden's on the state, and the state killed their case, so they don't have a case against him.
At the same time, I feel if we dismiss this with prejudice, there's going to be an open riot for all of this, and
they can riot, but they were wrong. That's the thing. I'm not much for holding the state's hand. They are the government, and they have every tool to their disposal. They have the advantage, but they also have the burden.
So I'm more without prejudice, just to the fact that they give them the chance to come back.
They did everything right up to this point where they screwed the pooch. Yep. I'm kind of leaning towards a dismissal without prejudice, because up until this point, they were moving down the field, and then they fumbled it right at the goal line.
Correct. So
on handling this case. So as far as that's concerned, I could see an argument that there is merit to this case, but at the same time, the way that this case was handled at the very end was a clusterfuck. So I'm tempted to dismiss this case without prejudice, and then if they want to bring the charges again, I'll let them handle that. I'll be more than happy for them to file to retry the case, but I'll leave the ball in their court.
No, I'll settle for that.
Closing.
Yep. All right. So we'll let them do their closing, and then we'll go from there.
Yeah.
All right.
All right. All right, we're going to proceed into closing arguments. State, you have the floor. This is a clusterfuck. Prosecution.
All right, I don't have a closing statement at this time.
Your Honor, may we approach?
Yeah, approach.
Your Honor, I apologize. In the interest of not wasting any more of the court's time, if the state wishes to make a motion to dismiss the case, or on my motion, if there's no closing arguments to be made, we could, based on in light of the fact that they don't have any witnesses, I think it would be difficult for them to prove their case. So
all right.
I'd like to give an opportunity not to waste any more time.
Yep. That's where we're going with this. All right, y'all can step back. All right. After hearing both party sides on this case and the issues that have presented themselves in this courtroom, at this time, it is by unanimous decision of myself, the Honorable Judge Brown, and the Honorable Judge Aries, that this case is going to be dismissed without prejudice. All charges and fines, all charges will be removed from your client's record. There will be no return of fine money because there was no fines issued upon the arrest. As for the failure to appear, I will still be processing that because he was given a date and time to appear before me in this courtroom. He even acknowledged it, and he failed to show up.
If I may, Your Honor.
Of course.
I'd like to make an oral motion for dismissal with prejudice. The state has had plenty of time to prepare their witnesses. They even gave me a witness list that I've been preparing to cross-examine and defend against for over a month. My client doesn't deserve to go through that process again. I understand he was unable to be present today, and I can't excuse him for that, but for us to make all this preparation just for the case to try him once again is getting pretty close to double jeopardy. I don't want him to have to go through that again if the state has clearly failed to prove their case even by just bringing a single witness to court.
State, do you have any counter to this argument?
My only counter would be that we were only given a 3-day notice for the trial date, and as I'm sure you're aware, people do have other jobs that they have to attend to. So.
Let me look here. Aries, Brown, any comments on this?
On record or off record?
On record at this point.
Well, I do.
We can hear you.
Judge Brown, your comment on the record on the arguments.
I mean, I get the issue with this is that the state does not have witnesses. However, they do pose a valid argument, but 72 hours is, you can make some sort of notification whether you can or cannot be in attendance within that time. Honestly, it really, for most people, takes reasonably an hour or two. But still, I think I'm going to move with the dismissal without prejudice.
Judge Aries, your comments on record?
As far as the comments on record, I am also with Honorable Miss Bliss and with Mr. Brown as far as without. Due to the fact that, one, your client decided not to show up, as well as two, the evidence has been shown, as well as there's other avenues of this. There's no witnesses, even though there was a witness list provided. So.
Your Honor, I do just want to state I don't believe my client decided not to show up. That would only be as fair as it is fair to say that state's witnesses decided not to show up. And if the state gets a do-over and no harm, no foul for not being able to prepare their clients or ask for a continuance within the next 72 hours, then I would also ask that my client be forgiven for his failure to appear, as he had the exact same amount of time and notice, and he shouldn't be punished for his non-appearance, whereas the state has no such remedy or relief.
Your concern is
Whose
noted.
phone is that?
Defense, your concern is noted on record. However, like I have stated numerous times during this trial proceeding, your client did respond to the date and time which I set on the docket, indicating that he would make an appearance, and he failed to appear. He knew he was supposed to be here. He acknowledged that he would be here, and then he stopped communicating. That is a failure to appear before my court, and I will not accept that. It is unanimously decided by all three judges. This case is dismissed without prejudice. The charges will be removed from your client's record, and I will not put out a warrant for his arrest for the contempt, but I will be charging him for failure to appear. This court is now adjourned.
I might need a hand here. I've had trouble with these doors. Thank you. Appreciate it, folks. Hey, at least there was
I would have kept it with a warrant.
always good
I would have honestly done it.
Because the only reason I did not go with the warrant is because the other charges were dismissed. Because those didn't because those charges ended up getting dropped. I'm not going to move forward with a warrant because that kind of seems a little much. But I will still charge him the fine for failure to appear.
Okay. I am gonna go fall asleep on my chair.
All right. Any objections to that, Mr. Brown?
No.
Yeah, I thought that was the best due course. Like, if we would have moved forward and he would have been found guilty on any of the two charges, then I would have also issued the arrest warrant for the contempt of court. But because those were dismissed, I gave him the grace of the court, and I'm just going to fine him for not appearing before the court. Because he did acknowledge the date and time and indicated that he would be here. So that's that. All right, I'm going to go process this. Right. So since I have you here, I'll walk you through how that works. So in here on the judge's chamber desk, if you look at the center mat there, you'll see judge's menu. So what you'll do is you'll open this, you'll create the court case, and you'll name it whatever the name is. We already have it named, so you don't have to worry about that. Once you have it named, it'll bring you back to the main menu. Then you'll hit, or it'll either do that or knock you out. After you created it, you'll go back into here. You'll do configure case, and then you'll select the case that you just put in. When you click on it, you can change the date the case is taking place. If there's any fees associated with it, you'll put in the fee amount. Under the people's on the case, the judge will be you, and then defendant, doesn't matter what order you put them in. You just got to remember who's who. You'll put in the defendant on the case, and then if it's a criminal case, so if it's against If it involves SAST, it'll be Daniel Sanders. If it's a civil suit, it's at whoever the other civilian being sued is. Once you get all that filled out, you'll hit start court proceedings and it'll send it out here. So out here in the middle desk, right here on the file, it says case management. So we'll select, I'll select that. I select my case that is being worked. So then with that, I need to change the fee. So I will come in here. So make sure you'll just double check to make sure that your fee amount, not everything's correct. The people that are supposed to be on the case are still on the case. Then you'll select payments. And then we'll select the who needs to be paid out. So if it's a return of fines, you'll select Daniel Sanders. If it's a fine, if it's going towards, if it's a fine amount going to the defendant, then you'll select them. So this one is, and then I will be charging him the no-show. And I've issued that. Usually with payout, if you select the option to pay out the fine amount, it'll automatically pull it from the account of the person that you selected, so they don't have to be present to make the payment. Once it's done, you will hit finish proceedings, and it'll close out the docket. Any questions?
Nope, seems simple enough.
Yep. It's also in the in our document of how to be a judge. It covers it, but it's once you do like one or two, it makes it a lot easier. I got you stretching here, there. But once it comes to that, if you want me to walk you through it at that time, I'd be more than happy to.
Alrighty.
All right, thank you.
Yep.
And then Miss Bliss, I got 2 questions for you.
Okay, give me 1 second to adjust Mr. Banks.
The second question, I'll have to talk to you without Honorable Hunter Brown around. No offense.
What's your first question?
First question, I haven't been able to get a hold of Sean Quinn. Are you able to find him to the department for me? So I can get a hold of him to bill him.
Okay, say that one more time.
I haven't been able to give him the fine amount because he hasn't been around. Are y'all able to find him through the courts? No.
Find who for what?
Sean Quinn for unlawful discharge or what was it? Discharge? Let me make sure. Yeah, unlawful discharge of firearm. The $10,000 fine.
Is there a case on it?
PC 1085. I've already reached out to administration about it as well, but he hasn't visited the station to even talk to administration about his employment either. So. $10.85.
Do me a favor on that. If you could message me the case number. I'm looking right now and I'm not seeing it immediately. It might be archived, so I might have to.
No, it's not archived. It has it listed as finished/pending. I'll tag you in it.
Don't mean to interrupt, but now that everything's complete, I'm just gonna say, y'all have a great night.
You too, Coleman.
Stay safe. I'm gonna stick around for a bit.
Okay.
Yeah, I'm not. Oh, finish slash pending. Gotcha.
Yeah.
So this is.
You sign a plea agreement for the discharge of a firearm unlawfully.
Gotcha. Oh, yep. Since it came through my court, I can do that. I can handle that fine amount and send it over to Daniel Sanders.
state.
Yeah, to the state.
Second question that I have. Hypothetically, if a doctor were to not fill out a medical report, could said doctor be charged with fraud?
No.
Okay. We don't have anything in the penal code regarding that, do we?
Because fraud is 217. A person commits fraud or forgery when they A, knowingly alter, create, or use a document to defraud another, or sign a document without authority, or misrepresent a material fact or for financial or personal gain, or possess, manufacture, distribute counterfeit items, seals, or trademarks. So if they didn't fill out the paperwork that they were supposed to, that's something entirely different. That's more like a dereliction.
I was about to say I've been going through the penal code a lot, and I can't find a single
Because
charge
that
that
would be like
Like I
a
say, that's more of a
dereliction, derelict duty, but we don't really have a.
That'd be something I would take up to their command, but
I don't see that happening. Considering that they're the O2 of the department, and they're in a relationship with the O1 of the department.
yeah, that sounds like a conflict. Might have to go to SADOJ. Would they handle something like that?
Sure.
I mean, isn't that their duty to make sure there's no people doing the jobs they're supposed to? Within the government, at least?
SADOJ is internal affairs for SAST. Not
Yeah, but couldn't they handle things like that though? Since there's really no one to.
It's no longer a utilized department anymore, so they can't do it anymore. They used to be able to, not anymore.
Well, that's too bad. Well, that just seems like the EMS kind of could do what they want and no one could say anything type deal, which is kind of strange.
Yeah.
You know what? Let me look at something real quick.
Do the searching. I know you can find it.
Saving plates.
Because I know typically you would take to like, what is it called, the medical board or something like that. But we don't
Yeah,
have
for dereliction of duty, but we don't have that.
Right. So it makes it a little bit harder because we don't have nothing in the penal code either. I mean, I guess the person could sue the doctors, but I don't know how well that will go either. If a paramedic was sued for malpractice, would they lose their medical license?
If they're found guilty of malpractice, then yes.
Do we have anything regarding malpractice? Or is it just something that they would have to take to court about?
That would just be something that has to be brought to court. Offense of necessity to protect themselves from others. Leave, entrapment, duress, person. Officer discretion, good Samaritan cause, citizens rash, privilege, pursuit probable cause, and plain view policy, arrest and detainment policy, searching warrants, new to combat,
on my phone.
Traffic offender and stops.
That's not mine. Was that yours?
No, mine's on airplane mode.
The one, the bailiffs.
I think I'm the only one awake now. I think the other two went to sleep. Unless it's ringing and not tell me it's ringing. But I turned my sound down.
Okay, technically, so per LP29 HIPAA regulations, law enforcement officers are permitted to ascertain HIPAA-protected documents, medical information, medical records, and other healthcare information in two ways. The medical patient provides law enforcement with consent, or the law enforcement ascertains a search warrant via LP25 or other court order. If a violation of HIPAA has occurred, the involved persons are subject to criminal charges via 620. Person's medical records, medical information, or other general healthcare information is as it relates to the patient. So, I mean, technically, if a medical personnel has failed to do their job and fill out the paperwork, technically it would be a violation of LP29. If they failed to fill out the paperwork and that paperwork has been requested via HIPAA release form or a court order, then they have violated HIPAA regulations by not completing the paperwork. Technically. But I don't even see a 620 here. What?
I was about to say, 620 isn't in the penal code.
Yeah, so the LP, it says there's a HIPAA regulations, but it's not even in the... Oh, Lord.
because the most it goes for Title VI is 609. So, because there's only 9 subsections for Title VI. So,
unless it was remade to if the Health Insurance Portability Accountability Act used to be 620. Let me look at something else here.
the only thing I see about HIPAA is 609. But if the patient's the one requesting the documents and the doctor is saying that they don't have the documents, that's kind of an issue.
Question: was there a court order for them to release the records?
No. It was requested by the individual that was involved in the accident.
It was okay. Was there no?
Are you the one with your phone ringing?
I guess the walls have a fucking phone, because this is not mine. I'm on airplane mode.
It might be Hunter. I think Hunter's back there still.
I'm gonna go check.
I mean...
Because the patient themselves shouldn't be required. I mean, yeah, you can fill out a form for the request for medical records, but like there shouldn't be a hold on it, especially when
actually, it
when
might
it's past
be
like 2
Jay.
weeks.
Oh, that'll do it.
Nice.
So if there's a court order for the records to be released and they say they don't exist, and that's contempt of court. Outside of that, I mean, is it if it's for a patient that has ongoing court litigation and this is preventing them, it could be considered obstruction.
Yeah,
then
that's why I asked Mr. Brown not to be here, because he's the sitting judge.
Okay, well, in extreme cases, it could be classified as obstruction. of a judicial proceeding because the records have been formally requested and by the patient and the doctor saying they don't exist. I mean, technically, one, that's dereliction of duty by the doctor, and two, that is technically obstruction because I'm sure the patient informed them what it was needed for, and the doctors are saying that it doesn't exist and they're failing to provide it. That could fall under obstruction. I mean, the other option is to call them to the, I mean, well, I guess the only other option in that case would be, I swear to God, if they don't answer their fucking phone. I mean, I guess technically the other option is them get called to the stand.
Okay, I'm gonna go look and see.
But I mean, as for records, yeah, I mean, we have nothing on the books for that. There's nothing federally on the books for that. Outside of, in extreme cases, it could be considered obstruction. If there was a court order for them to be released and they say it doesn't exist, that could be considered contempt of courts.
Let's see. Oh, my filters don't work. Oh, that's great. Okay.
I have no clue where it's coming from. There is no one else around.
Avoid headaches, nausea.
Okay, so
Hell hydrate.
incident
Hell
itself
hydrate.
took place on the 16th of May. The civil suit opened on the 17th, and they have still yet to get medical records. So, a day after the incident. So.
I think he's talking about my Mamba Blues case. Yeah, I mean that's all I got at the moment. I mean, outside of that, really all you got is a spoliation claim.
Yeah, I know a lot of people hate us state prosecutors. Everyone thinks we're pro cop. Listen, all I'm saying, right? You do wrong, gonna be held accountable. Just saying. No one's free from justice. I am justice.
Are you Batman?
Yes. Justice for Gotham.
Gad, he's Batman.
Listen, you've never seen me and Batman in the same room, have you?
No.
Exactly.
I never seen Batgirl and Emma in the same room either. My God, she's Batgirl.
Suspicious.
When the criminals get away in the courtroom,
Here we go.
he gets the criminals on the streets.
Rule 37 of the Federal Rules of Civil Procedure. for electronically stored information. This is what the courts are usually. This is what gives courts inherent authority to sanction misconduct. This is normally what the courts use to address spoliation. So, I mean, that could be in violation of Rule 37 of the Federal Rules of Civil Procedure.
Yeah, because my issue is this isn't the first time that this has happened, so... You know.
Who's the doctor?
Brianna Rice.
God damn it. No, it is not the first time she has failed to do her job.
And that's why I say going to her command wouldn't be beneficial, because he is dating Maisie.
Is Maisie the current fire chief?
Yes. Maisie is currently 01 and Brianna Rice is 02. So you can see the predicament that we're in.
I mean, at this point, the legal... You would have to follow legal procedure to do anything in regards to that situation that has created this dilemma. If the top two are in a relationship, that would be a conflict of interest of trying to get one to do something against the other. Oh, what a clusterfuck this is.
Yep.
Yeah, from what I'm seeing, that's the best I got for you.
Okay. Because it's both a civil and a... I mean, it's a civil suit either way, but it's against both the department and the individual. So it's... Bradley's taking the individual part, and I guess I'm taking the actual department part. So... I don't know. Bradley hasn't really talked to me about it.
If the hospital is failing to do their job, then after a patient has requested their stuff, then the next step would be use the courts for that information. And if they still fail to cooperate, then there would be legal grounds for action be taken by the courts of this state. But outside of that, we don't really have anything on the books that would address this current situation.
I figured, but I just wanted to get some clarification on it.
Yeah.
Alrighty. Well, I'm gonna head back to the house before I pass out. So.
All right. Have a good evening. Yep, he was totally talking about my case. Totally talking about Blue's case. Can I jump off the bridge yet? No? Okay.
Nope. Because I'll jump with you.
I gotta write up the DOJ for this.
Oh, you get all the fun.
I already charged him for failure to appear.
Yeah. Gun's bright.
It's okay. That's a nice chunk of change. I was looking at it. It's $100,000 for failing to appear before a court when ordered.
Oh, that's crazy.
So if you get charged, you better show the fuck up. If you say you're gonna show the fuck up.
All you can do.
Like I went to process and it's like, wow, that's a lot of zeros. So yeah, I gotta type up the DOJ for that. It's dismissed without prejudice.
that means we get to go back to this at some point, possibly? Well, you do. I just see the stand look beautiful.
Oh, if it comes back to the case, I'm gonna look at Jay and be like, "This one's yours now. I'm done. I spent over a month working on this. You have fun with it."
This whole thing just, I'm surprised he didn't just go, you know, evidence proves he did this, guilty, and just called it good.
Brown had a valid point. There was no, like, what the defense said. There was no, what was the term again? There was no record on the evidence on how this who provided the evidence and so on and so forth.
Because they didn't go through and actually attach the evidence and stuff to their warrant reports and whatever.
It was submitted during discovery. And there's chain of custody. There was no chain of custody submitted with all of it. And because there was no chain of custody, technically, it became inadmissible in court.
I don't think, do they even have a chain of custody in SAST? I don't know.
They do. You just have, they just have to say, hey, this is where the evidence came from. This is who collected the evidence. This is where This is who collected the evidence. This is where the evidence was stored, and this is who provided the evidence. Like if it's a body cam, this is who provided that evidence. And the defense got him on that one. Like, because the defense made that objection, made that statement, they got him. They didn't let prosecution slip by with that one.
Oh, I don't know. I'm glad I don't work SAST. I don't know how my cousin does it.
Yeah, if there would have been witnesses to corroborate the evidence, that's one thing. Or if they would have submitted a chain of custody for the evidence of who collected the evidence, who provided the evidence, where the evidence was stored and all that, that would have covered it as well.
Yeah, I'm just trying to figure out, like, I don't know, there's so much that just seems to go, certain mentality, it seems like, that seems to happen when it comes to collecting stuff, and then that's it.
What a mess. Well, I can put in the paperwork now and close this docket out, and my docket will be empty for,
oh my god, what are you gonna do?
Maybe like 48 hours, and then there's other cases that need handling.
Well, I can't help you, I'm sorry.
Yeah, you can. You can stand there.
Oh,
and bailiff.
I do that very well.
Yep.
Trust me, there's certain dockets I handle that just drive me as nuts as probably yours.
Now that you have the whole
government job, yeah.
Well, I was talking about the ankle monitor system, so you're about to be a lot busier because y'all would be assigned as their probationary officers / parole officers. So,
well, see, until I am actually able to drive a car and afford a car, I ain't gonna be doing any of that because I can't go anywhere.
I'll just make their asses show up here.
And then what if they don't want to? I'm gonna have someone come find you. I don't know who yet. I just go run to wherever they're located. I hope they just give up at that point and be like, my god, you actually, wait, what? That isn't gonna help.
But I mean, yeah, I guess you don't have a bailiff car yet, but I mean, if they're doing sketchy shit, you just call SAST and tell them, all right, pick them up. They violated their probation / parole. That's all you do.
They're doing sketchy shit, doo-dah, doo-dah. Problem is, I have to actually be physically awake to see that.
Yeah, true.
And the other thing is, if they do too much sketchy shit, then I see, I gotta deal with it a different way.
Yep.
Make me cry.
Anyways.
So, now what?
Now that this mess is done, I'm gonna go curl up and die.
You can't do that.
All right.
Curl up and die. Can't do that. It's not good for your health.
Allegedly.
I mean,
Allegedly.
they always say it's not good for your health, but who's to decide what's good for your health?
Exactly. Not the doctors in
Because
the
me-
state because they're too lazy to do their job and fill out
Oh,
paperwork.
good lordy. I've heard, and it sounds like it's the second time she's done this.
Yes. All right. Well, time for me to lean on your shoulder and go to sleep.
All right, I'll take a nap with you.
Ugh. Yep, that's it. That's all she wrote. State v. Banks is done. Oh, well, thanks for hanging out. Gotta write up the DOJ for this and get this docket closed out. But keep putting in the hard work because one day it'll pay off and we'll be back one day. Take care, everyone.
Blådogsdagen